Welcome to Legal Talks. Today I will talk about recovery of public money. What is public money? Public money means funds obtained by the borrower from the government and its entities, including banks. Mind well, recovery of public money has always been a very serious problem in our country. Public money recovery of dues act were earlier passed by different state governments, but were largely restricted for institutions like state financial corporations. And the recovery prescribed in those acts was essentially as an arrears of land revenue, a very speedy mode of recovery, but did not turn out to be effective. Thereafter, Central Act was passed, namely the Recovery of Debts Due to Banks and Financial Institutions Act 1993, which is still in operation. It provides special mode of recovery, and a special machinery is set up under the Act. You must have heard the name DRT, Debt Recovery Tribunal, a trial forum for the recovery under the Act, an appellate tribunal, an appellate forum under the Act. The 1993 Act, while establishing DRT and appellate authority, also prescribes the procedure to be followed by it. As I have told you, DRT under the Act is a trial forum, and therefore DRT, after holding inquiry, is required to issue certificate of recovery against the borrower. And the procedure prescribed is that recovery officer authorized to attach and sell the property as also to arrest the defaulter. A very fast procedure than the civil court. But the person aggrieved can prefer appeal against this order within 45 days before the appellate tribunal. As this did not fetch desired results, the present Act is passed. Since the said Act is still in operation but did not fetch the results as expected, the present law relating to recovery of public money is passed. The nomenclature given to the said Act is the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002, which is popularly known as Sarfaesi. The special features of this Act are very important. Most important of the other aspects is that civil court is not to have jurisdiction over the subject matter covered under the Act, and no injunction can be granted in respect of action taken under this Act. So, in substance, powers of the civil court are taken away by the present Act in order to make the recovery faster. Further, it says that the Act has overriding effect over other laws, meaning thereby the provisions of this Act gets precedence over the provisions of any other Act. In other words, if there is any conflict between this Act and any other Act, this Act prevails. At the same time, mind well that this Act is in addition to other Acts like the Companies Act, the earlier 1993 Act which I referred, SEBI, etc. Not only that, The machineries established under the 93 Act, namely DRT and Appellate Tribunal, are also the authorities under this Act. Further, claim by the institutions must be within limitation. This is very important feature in favor of the borrower. At the same time, the very negative provision qua the borrower is that the restrictions provided in section 69 and 69A of the Transfer of Property Act do not apply to the proceedings under this Act, meaning thereby that certain restrictions and procedure to be followed in case of immovable property do not apply to the present case, which we will see later on. Now look here, the borrower is defined under the Sarfaesi Act, and it says who is borrower. Borrower is person who is granted financial assistance by a bank or financial institutions. And for this act, the guarantor is also included in the definition of borrower. Not only that, the scheme of the act is that securitization or reconstruction companies act on behalf of the lender. In such situation, it may not be taken as a defense that I am not the borrower of the securitization company. Therefore, provision is also made with regard to that situation, stating that one who has created mortgage or pledge as security for financial asset also becomes borrower of securitization or reconstruction company consequent upon acquisition by it of any right or interest of any bank or financial institution. So you can visualize that how the definition of the word borrower is widened under the Act. Now, in order to avoid any difficulty, the default is also defined. What is default? Default means non-payment. Of what? Of all enumerated items, namely principal amount, date, interest, or any other amount payable by the borrower, obviously to the lender. But a rider is put that which is classified as NPA, means non-performing asset, in the books of accounts as per RBI guidelines. Now I may tell you here that RBI has issued guidelines when an account can be termed as non-performing assets, and it has to be accordingly done, and then it is termed as default under this Act for initiating actions under the present Act. Now look here, financial assistance is also defined, and it says financial assistance means loan or advance granted, or even debenture or bond subscribed. So subscription to debenture or bond would also be a financial assistance, or any other guarantee given, and letter of credit if it is established, or any other credit facility extended by bank or financial institutions. So, widest possible coverage that any sort of financial help is termed as financial assistance, for which action can be taken under the Sarfaesi Act. Just as financial assistance has been defined, financial asset is also defined, and you will come across this phrase throughout the Act. It means any debt or receivables. and even claim to debt or receivables. Further, it says any debt or receivable secured by mortgage of or charge on immovable or movable property. On movable property, popularly it is known as pledge. Further, even interest in security is also included in financial asset. And much wider provision is made that beneficial interest in property is also included within the meaning of financial asset under this Act. It is immaterial whether beneficial interest in the property is conditional or contingent. So, it is very clear that definition of financial asset is also made much wider than what we understand in common parlance. Now at this juncture, I will talk about procedure for taking possession. So it is very fast and very special. It says when possession is required to be taken or sold or transferred, any other contingency, mind well, the secured creditor, the lender, may make an application to whom? To the Chief Metropolitan Magistrate or the District Magistrate having jurisdiction over the area to take possession thereof or documents. Even application can be made for documents. Such authority shall take possession and forward such secured assets and documents to the secured creditor. The authority can use necessary force for the same. And very important is no action of magistrate under this code shall be called in question in any court or authority. So very harsh, fast step, but obviously in the interest of public, and therefore a very nice step. Now please be clear, when possession is taken in such a way, the question would be whether the borrower has no remedy. The answer is no. There is remedy. And court says person aggrieved by such action may prefer an appeal to DRT within 45 days of the measures taken. So I have told you earlier that DRT and appellate tribunal are also the authorities under the present act. So within 45 days of the action taken, aggrieved person can prefer an appeal. But the limiting factor is that while preferring this appeal, 75% of the amount is required to be deposited. Of course, the power is given to DRT, and DRT may waive or reduce the amount after recording the reasons. So it is not as a matter of course. And still, if the DRT decides against the person and the person is still aggrieved, he can prefer an appeal against the said order of DRT to the appellate tribunal within 30 days from the receipt of the order. So you cannot say that the borrower is remediless. He is given two remedies, one to the DRT, the other to the appellate tribunal. The only point in favor of the borrower is provided in the Act is the relief against wrongful action. And what is that? The law says that if the action taken is found to be wrongful, DRT or the appellate tribunal can direct the secured creditor to return the assets and further direct to pay compensation and cost as may be determined by it. But ordinarily you can appreciate that this may not happen. Now what is NPA? Non-performing asset. It means an asset or account of the borrower which has been classified by bank or financial institution as substandard or doubtful or lost asset as per the RBI norms. I already told you earlier that RBI has issued lengthy guidelines for ascertaining these categories and accordingly it has to be done. If it is done that way, it becomes NPA account. Now very important thing, property. What property means under this act? Because the property of the borrower, the defaulter, is to be taken and to be realized towards the NPA account. Therefore, property assumes importance. What is it? It is movables, immovables, debt, even any actionable right, intangible assets, know-how, patent, trademark, license, franchisee, or any other commercial right. So you can visualize that how far the definition of property is wider and all possible earthly things are included within the meaning of the word property. Having told you about the act, I may tell you the procedure to be undertaken under the act. And it specifically says that despite section 69 and 69A of the Transfer of Property Act 1882, I told you earlier that these two sections provide for certain regulations and restrictions before effecting the litigation against the immovable property. So without having regard to that, overriding effect is given to the provisions of this act. Enforcement under this act can be taken without the intervention of court. Once the borrower is classified as NPA, then the notice has to be issued calling upon to discharge in full within 60 days. If the borrower fails, action can be taken under the present act. This notice must contain details of amount payable and the secured asset intended to be enforced in case of non-payment by the borrower. Mind well, after having issued notice, if the default continues, any of the following actions can be taken. Firstly, can take possession of secured assets, including the right to transfer by way of lease, assignment, sale, and realize the secured asset, for which I already told you that application has to be made to the magistrate. The second measure can be taken is to take over the management of the secured assets, including the rights, etc. Third important measure which can be taken is to appoint any person which is known as manager under the Act to manage the secured assets. As if this is not sufficient, the lender can also require any person to pay by notice who has acquired any of the secured assets from the borrower. or from anyone from whom any money is due or may become due to the borrower, as is sufficient to pay secured debt. So, even borrowers borrower are also liable under this act. Now mind well, certain restrictions are also imposed in order to see that the purpose of this act is materialized. How? That is mentioned here. No transfer after notice without prior consent of the secured creditor. Meaning thereby, once the notice is given, the defaulter cannot transfer the property. Any transfer of secured asset after notice, after taking possession or management by a secured creditor shall vest all rights in the transferee as if by the owner. So virtually everything is passed on and straightway the transfer is effective and all costs are on the borrower. However, very important provision is made that if the amount is paid before any time fixed for sale or transfer, no further steps shall be taken. However, if the same is insufficient, the secured creditor can file an application to DRT for recovery against guarantor or sale of the pledged assets.